Jones Zone. Today is part one of a two-part episode that you won't want to miss. We're going to do a deep dive into the complex world of California property taxes with our special guest, Michael Kelly, a real estate property tax attorney. We'll be covering everything from Proposition 19's key provisions to its impact on transferring property between parents and children. If you've ever been curious about how these laws affect your property and wealth, you're in the right place. Let's jump right in.
Welcome to the Jones Zone, a podcast by Darryl and JJ Jones.
So explain to us, what are the key provisions of Prop 19? How they impact property owners in California?
That's a great question. So, Prop 19 brought about some major changes to property tax rules in California. Primarily, it impacted two exclusions that Californians once enjoyed. One is the parent-to-child exclusion. It severely limited the options under the parent-to-child exclusion. And the other is the base year value transfer exclusion that's available to a certain category of individuals we'll get into, I'm sure. It expanded the options for those folks. So it had a pro and con effect on these two exclusions for most Californians.
If I remember correctly, let's go to the second one, because before, when you're over 55,
that's one of the category of individuals. There's a couple others, disabled individuals and victims of natural disasters, but most applicable to those 55 and over.
Prior to Prop 19 passing, how did it work? Can you explain that in terms of anybody 55 or older, just for the 55? Well, for those folks, those category folks,
sure.
What would happen?
Yeah, so if you were age 55 or older, you had the opportunity to transfer your base year value, the taxable value of your home, to a new home, so long as you're transferring it from a primary residence to another primary residence, or replacement primary residence as they called it. But there were some limitations tacked onto that. One of the limitations was that you could only transfer to a home of equal or lesser value from your original home if there was a staggered measure of equal or lesser value, depending on when you made the transfer. If it wasn't of equal or lesser value, if the home you were transferring your base year to was greater in value than that staggered measure, you didn't qualify. It had to be equal or lesser. So it was mainly for folks who were looking to downsize, move into a retirement home, a smaller space. They didn't need the square footage that they had currently. And if you met those requirements, that you qualified. The other limitation was you only qualified if you were moving within the same county to a new home, or to a new county that had reciprocity, which means that it also offered an over 55 base year value transfer exclusion. It varied county by county, not all counties offered it. So you had to be moving to another county that had reciprocity. If you were moving to another county that did not, you weren't able to take advantage of the exclusion. That was the rules under the pre-Prop 19 base year value transfer exclusion.
And the thinking was, for those individuals who been in a house they bought it for $100,000, it's now worth $1.5 million, and to keep, and they're oftentimes on fixed incomes or et cetera, and it would just keep their property taxes lower based on that $100,000 purchase, and it can go up 2% a year. There are limitations. It's just basically preventing an enormously high tax bill.
Yeah, the drafters recognize that folks at that age range who are looking to downsize might want to downsize or need to due to their age, but couldn't otherwise afford it because they couldn't, they enjoyed that Prop 13 tax base that they bought into in 1970. And now if they were going to move into a new home, they'd buy into a home that would be traditionally reassessed at fair market value. And they couldn't afford that. Their savings hadn't accounted for that. So they allowed this exclusion for folks to take advantage of it if they qualified and they met those parameters, again, under the old rules. One other thing under the old rule is that you were only allowed to do it once. You had to make sure that the home you were moving into, the replacement property, was going to be your forever home, because you couldn't get another shot at it if you didn't like it a couple of years into it. The one exception to that is if you took advantage of the age 55 and older exclusion, moved into your replacement property, and then later became disabled and qualified under that category, they would give you another shot to move into a new home that accommodated your disability if your current replacement residence did. So they gave you that one extra shot, but traditionally it was just one opportunity to take advantage of the exclusion, which has since changed under Prop 19.
So that would probably be what most people think is a good thing. The ability to not only not have to buy for equal or less value. So you can do it more than once now.
You can do it 3 times now. And that's even if you took advantage of the exclusion under the old rules. So
that's huge.
Yeah. And it's per owner. So per spouse, if you're doing it between spouses who each qualify as age 55 and older.
So now what happens, maybe you can explain, give an example of. So for example, I'll give an example first, and then I'll let you try to maybe further clarify. So one could sell $1 million house. They sell their $1 million house. They'd have to buy something around $1 million or less in order to transfer their current low taxes. This is prior to Prop 19. And now they can buy whatever they want. And then what happens? So they can now, instead of having to stay under $1 million or $1 million or under, they now can go, let's say $1.5 million. And explain to me what happens then, if that's okay.
Sure. Yeah. So the staggered measurement, just for clarification, of equal or lesser value as it's defined, is you have 2 years to buy your replacement property from the date that you sell it. You can also buy your replacement property before you sell your old home. Well, let's just take it as if you bought the replacement property afterwards. You have 2 years to do it to qualify. That's under the old rules and the new rules. So if you buy your replacement property within the first year of the sale of the original residence, the measurement of value is 105%. So it's not exactly $1 million. You have that little buffer even under the old rules of equal or lesser value. If you buy it within the second year, so after the first year, between year 1 and year 2, it's 110% is the measurement. So if you're within that buffer zone, you're still within equal or lesser value under the old rules. But now under Prop 19, you don't have to be within that buffer zone. It still exists in terms of whether you fully qualify or not. But if you buy a home at 1.5 and your original residence was 1, you're not going to be within that buffer zone. And the delta between the fair market values of those two homes is what gets added on to the base year value that you're transferring. So your Prop 13 value that you've enjoyed and you want to transfer to your new residence gets transferred, but the added value that you've purchased into gets tacked onto that base year value. So let's say your base year value is $300,000. That $500,000 delta would be a little different because you'd want to account for that buffer that you get to take advantage of. But that delta gets added onto that $300,000, and that's your new taxable value under Prop 19 and Prop 13 that gets trended forward thereafter once you've qualified for the exclusion.
Got it. That was a very, very good explanation. I've asked multiple people that, and that was never been explained better than how you just explained it. So thank you for that. Sure. I appreciate that. All right, I'm going to go into some of these questions now. It's funny because I think some of the questions you may have already answered even already. So let me just pose these here. How does Prop 19 affect the transfer of property between parents and children or grandparents and grandchildren? How does it affect that?
Yeah, so that exclusion, the other exclusion that it impacted was the severely limited exclusion. Prop 19 restricted the ability for parents or grandparents to transfer property to their children or grandchildren, respectively. Keep in mind, it also works both ways. Children can transfer property to their parents or grandparents, grandchildren to grandparents. It works both ways. Most often you're getting parents transferring to kids, so we'll just stick with that. But just know under both the old rules and the new rules, it works both ways.
Okay.
So you used to be able to transfer principal residence of the parents to the children, so long as it was the principal residence of the parent immediately prior to the transfer, regardless of what the kids did with the property thereafter. Now under Prop 19, it has to also become the kid's principal residence within a year of the transfer in order to qualify for the exclusion. If you had a property that was not a principal residence of the parents, it was just an investment property, you used to be able to transfer up to $1 million of trended base year value of that property to your kids. That amount was tracked by the State Board of Equalization. So you had up to $1 million of trended base year value, which if you had a bunch of property you acquired in 1980, they're going to have low base years on them. You could transfer several properties leading up to that $1 million and qualify for the exclusion. Now under Prop 19, you don't have that option. It has to have been the principal residence of the parent immediately prior to the transfer. If it wasn't, you don't get the exclusion. So Prop 19 severely impacted the ability to transfer wealth intergenerationally in California, and it really impaired that.
Primarily, just to kind of review what that actually means. So for example, a child their parents' demise, they leave their child this $1 million property, and the child oftentimes has not the income that their parents have sometimes. So either way, that's irrelevant, I suppose. And so they would also benefit from having that low taxes, but now it gets reassessed and their taxes, their property taxes would go up pretty significantly and the way to avoid that with the new Prop 19 is they have to move into it. Not only do they have to move into it, this is something I heard, and one of the reasons or another question I have to ask is, from what I understand, so they leave it to one child, that child would have to move into the primary residence also to keep the tax low, property tax low. And here's one of the complaints I've heard is if they leave it to, let's say, two kids, which oftentimes, people have multiple kids, and they leave it to two kids. This new Prop 19, they both would have to move into it. Is that correct?
No, just
Okay.
one eligible transferee has to move into it and occupy it. In order to qualify, they would need to, depending on how the property was transferred, if it was via a trust and the trust called for it to be distributed equally to both kids have to be on title to qualify, unless you did a non-pro rata distribution, which gets a little more technical. We might get into that later on, but let's just set that aside for now. Only one kid has to move into it and occupy it as a principal residence, but they also have to file what's called a homeowners exemption, which is a form with the assessor's office that designates a particular property as your principal residence. And that's how the assessor gets notice that you're using this property as your principal residence. So you have to move in within a year. That's non-negotiable, and occupy it as your principal residence. And you have to file for the homeowners exemption. To get the full benefit of the exclusion, you have to file for that homeowners exemption within that first year. And it used to be, under when Prop 19 was first passed, that if you didn't file that homeowners exemption within that first year, you were out of luck. You didn't qualify. But the state board recognized that a lot of people get those notices in the mail with the form for the homeowners exemption. It doesn't really mean a lot tax-wise for property tax purposes. It's a reduction of $7,000 of your assessed value, which translates to between like 70 or 80 bucks a year. So a lot of people don't really pay attention to it. They toss it, they throw it away. They don't think it really matters. So the State Board of Equalization opened it up and allowed you to file for that homeowners exemption after that year, so long as you've been occupying it otherwise as your principal residence, and still qualify for the exclusion on a prospective basis as of the assessment year that you filed that homeowners exemption in. So you can still get prospective relief. You'll have to pay on the uptick from the date that the property transferred up until the year that you file it in, but you could get application of the exclusion moving forward if you then file that homeowners exemption, so long again as you're occupying it as your principal residence. Sure. So the other interesting part about Prop 19 and the parent-to-child exclusion is, again, the child or the transferee, if it's a parent, has to occupy the property after the transfer as their principal residence. And that's the only way that they can qualify. If they do so and then later move out and say, hey, you know what, I think I could be making more money on this property. It's an investment property. I want to start renting it out. If they move out and no longer occupy it as a principal residence, they're supposed to notify the assessor's office that, hey, I want to cancel my homeowner's exemption. I'm not occupying it as my principal residence. And at that point, they'll lose the exclusion. But it's not a full reassessment in the traditional sense, where it would be reassessed to fair market value as the date that they move out. Because they took advantage of the exclusion, the assessed value gets recalculated to the fair market value as of the date that they took advantage of the exclusion. So as of the date they originally got the property, whatever the fair market value was then, and that value then gets trended forward under Prop 13 to the date that they move out and no longer occupy it as their principal residence. And that's the new taxable value of the home. So there might still be some savings there if you want to take advantage of the exclusion and then later decide to do something else with the property, but still own it if you can afford it. To get the full benefit of the exclusion and maintain that low base, you have to continuously occupy it as your principal residence for as long as you desire to own it. Otherwise, you'll technically get reassessed if you're doing things the right way and properly reporting when and when not you're occupying the property.
Let me ask you this. Now, you talked about reassessed. Who does the county tell you the price, or do they get appraisal done, an official appraisal? How does that part work?
The county assessor's office conducts an appraisal. You can have your own appraisal done if you disagree with their value, or if you want to get ahead of it and tell them what you think the value should be if you know a reassessment's coming. But the county assessor's office has appraisers that they employ that value these properties, and they value them annually. They look at properties that have undergone a change in ownership that'll cause a reassessment, or properties that have technically declined in value from year to year that deserve a reduction in assessed value. And so these folks are conducting their appraisals, which you can get access to through a Revenue and Taxation Code Section 408. It's a request that you submit. Say, hey, I want to see how you value this property. Give me your work papers. And every taxpayer has a right to their file. You can see their workup. And they're usually using sales comparison approach, comparing the property to other similar sales in the marketplace near in time to the valuation date in question, or an income approach. If it's an investment property, commercial property, industrial property, they'll value it that way. Sometimes they'll do it on a cost approach if it's new construction, but they have actual appraisers that they employ to.
And if you disagree with that value, there is a formula or a way to dispute it.
Yes. There's an appeal process. It's an administrative process in California, and there are really, really strict deadlines tied to that appeals process. and they vary both depending on the reassessable event and vary from county to county. I'll just run through that right now. You might ask me to do it again. It's a little bit complex, but there's a couple different relevant deadlines. So the first general deadline is the regular filing period. That's if you want to challenge the assessed value of a property as of January 1 of each year. It reoccurs every year. Properties have an assessed value assigned as of January 1 every year. That's our lien date. That's the regular filing period, which we're in right now. It runs from July 2nd for 2024. It's July 2nd to, it's supposed to be November 30th, but that falls on a weekend. So it's trailed to December 2nd is the end date. You have to file within that time period in order to challenge the assessed value of your property as of January 1, 2024. If you file on December 3rd or 4th, you're out of luck. You've missed that window. To file a regular roll appeal, you have to file within that time frame. Now, if you have a change in ownership event that caused a reassessment of a property outside of that January 1 window, like if you sold to a third party, that property is going to get reassessed at fair market value, that third party disagrees. Let's say they bought it for a price way above what market should have been because there was some other incentive to buy it, but fair market value should be lower. They can file an appeal as of the supplemental assessment that's going to get issued due to that reassessable event, but it has to be either within 60 days of the notice of that supplemental assessment that's sent out by the county, or 60 days of the tax bill. Most counties, it's governed by the 60 days of the notice. The notice will have a mail date on it, and you have 60 days from that mail date to file an appeal application to challenge the value that they assign to it. If it's from the bill, like LA County is the bill, you have 60 days on the mail date on the bill to file a timely appeal. If you miss that 60-day window, you're out of luck. The other caveat to that regular roll filing window, it's July 2nd to November 30th in a lot of counties, but some counties, the deadline's actually earlier. It's September 15th. This year, actually, it's September 16th, because again, 15th falls on a weekend. Most Northern California counties are September 15th deadlines. Most Southern California counties are November 30th or December 2nd deadlines. Ventura County is an exception to that. They're a September 15th deadline. But you really got to know what your jurisdiction is and where your property falls, and know what the rules are that apply to that to make sure you're getting your appeals in on time, because there are really severe consequences. You could lose your right to a refund. Even if you pursue an appeal and succeed on your opinion of value, you won't be entitled to a refund because you didn't file a timely appeal jurisdictionally. And so you got to be paying attention to that. And the one other option that could apply to you is if you have a reassessable event, let's say in 2024, the assessor doesn't get around to reassessing it until 2028 or 2029. They'll issue escape assessments. They'll issue a supplemental assessment as of 2024, that change in ownership date, and then escape assessments for the value that escaped reassessment for those later years, 2025, 2026, 2027, and 2028, or that delta of that fair market value that you should have been paying taxes on due to that reassessable event. The deadline to file on escape assessments is also 60 days, either from the notice or the bill, depending on what county you're in. It's generally the same jurisdictionally. Most counties are by the notice. LA County is by the bill. You just got to know where your property sits. And again, if you don't get your appeal on time within that 60-day window, you're out of luck on challenging the value and getting it reversed.
You can't do it before or after. There's a window.
That's right. Yeah, you have to wait till you get those notices. Now, if you miss a filing on a reassessable event, like on a supplemental bill for 2024 change in ownership, let's say it's happened in February of 2024, and you miss the 60-day window, you're shoot, I don't get to challenge that base year value. You can file a regular roll appeal in the regular filing window, July 2nd to December 2nd, if you're in that county, let's say LA County, for example, and check off the base year value box on the assessment application, get prospective relief if you're successful in reversing the base year that was set by that reassessable event, by that supplemental assessment. So you'll miss out on the savings as of the date of the change in ownership, but if you file within the next opportunity, the regular filing window for that next year, you can get prospective relief and protect yourself that way and still get it reversed.
For our listeners to know, or viewers to know, is Prop 13, an amendment that was done back, I think, in the late 70s. The government could increase your property tax by, is it 2% a year? Is that what it is?
It's the lesser of 2% or the CPI index for any given year. Yeah, so Prop 13 is our overall property tax system that we live in. It was passed in 1978, and it rolled all assessed values back to March 1 of 1975. March 1 used to be our lien date. Now it's January 1, but it used to be March 1. So it rolled all those values back to March 1, 1975, what they were, and precluded any increase in value more than, like you said, 2% or the CPI index, whichever is lower. So that's tracked from year to year, unless there's a reassessable event, a change in ownership like I described, which Prop 13 didn't actually define, but it has since been defined by the legislature and codified in Revenue and Taxation Code.
Meaning, if your property went up 10%, your taxes wouldn't go up 10%. They'd only go up 2%.
Yeah, unless the inflation factor was lower, it'd go up less than 2%. It's capped at that Prop 13 limit as either 2% or the CPI. And
define to our listeners what CPI is.
Inflation factor. So, if inflation's below that 2% mark, it's going to be increased by less than 2%, but it's tracked annually by that. And unless there's a change in ownership event, at which time it would be reassessed to the fair market value, whatever that is, as of that change in ownership event date, it's not going to increase by more than 2%, the lesser of 2%, or the CPI index.
Other than a sale, what other events could trigger it?
That's a really great question. There can be transfers of property. Change in ownership is defined under Revenue and Taxation Code Section 60 as any transfer of a present interest in real property. So not a future interest. It has to be a present interest that includes the beneficial use of the property, the transfer of the interest of which is substantially equal to the value of the fee interest. Revenue and Taxation Code defines both the general rule as well as the Revenue and Taxation Code defines specific examples and situational events that could constitute a change in ownership. So for example, a lease that's signed that's greater than 35 years, including options to renew, is a value substantially equal to the value of the fee interest as defined under the Revenue and Taxation Code. Creating a lease 35 years or more will cause a change in ownership event. The property having been transferred from the landowner to the lessee as the new owner, because a lease of that term is viewed as substantially equivalent to the value of the fee. The lessee is the owner of the property for property tax purposes.
I know a lot of people, for example, will add their son or daughter or someone onto title. Let's say I'm a married couple and they go, well, let's just put Joey on title also. Is that another event that could be construed as a taxable or increase in your property taxes?
It is, yeah. And assuming you don't qualify for the parent and child exclusion on Prop 19 now, that would be a transfer of a present interest, including the beneficial use of it as a title holder, substantially equivalent to the fee. He'd be a fee owner in joint with the other title holders, and that would constitute a change in ownership event.
In a nutshell, if they're thinking about doing something, because I've had clients that thought, okay, well, maybe the best way to leave our house to our son, Jimmy, is just to put him on title now. I know it's probably unfair or wouldn't be correct in saying never do that, but that's probably, you want to talk to somebody before doing that type of thing.
Absolutely. And that's where a lot of people get into trouble, is they kind of do things, either they're refinancing and a lender is telling them, hey, we need you to add this person on or transfer to this person temporarily because they have better credit. They don't think anything of it, but ultimately it ends up causing them a reassessable event because they've transferred title. And that's a change in ownership that allows the assessor's office to reassess the property to fair market value as of that transfer date.
Ouch. Recently actually happened to me or us is they raised our property taxes 7% in 1 year. And their argument was, what they told us was that, well, it's gone up that much the last 5 or 8 years and we just didn't do it. I mean, I don't know. Am I making any sense right now? Our argument was, wait a minute, I thought it could only go up 2% a year.
Some properties are trending on a Prop 8 basis, meaning that the assessor's office recognized that in 1 year, the property value dipped below the trended base year value, the Prop 13 value. So, it was bought at one purchase price and assessed at whatever that value was, then only trended pursuant to Prop 13 at the lesser of 2% of the CPI index. But in 2010, for example, the property value dipped in the Great Recession, and the assessor's office recognized that, and they brought it down to that level and only assessed you at that level. And ever since then, you've been trending on Prop 8 numbers, again, not rising to the level of what the Prop 13 basis should be. That always exists. It's still there, but they've only increased you by whatever the decline in value has continued to be each year thereafter, until eventually the value, as they reevaluated every January 1, has reached back to that Prop 13 number. Then they can raise you up to that number again.
To catch up.
Exactly. Say, hey, your fair market value's either gotten back up to that number or it's exceeded it. So we're only going to raise you to that number because there's been no change in ownership event otherwise. But you've technically been trending on this decline that no longer is being recognized. And, if you disagree with that, you'd file an appeal in the regular filing window and say, hey, no, I think I'm still on this decline. It's not raised to that level yet. And you produce your appraiser who gives their opinion of value, and you fight it in front of the assessment appeals board.
It's 2% a year from the day you buy it to present day. On average, 2% a year. So it can be more than 2% any particular year based on what you just said because of that reason.
Yeah, if you've experienced a decline and it hasn't been raised back up to that Prop 13 value. But your Prop 13 trend of base year value cannot increase in any given year unless there's a change in ownership event by more than 2%, the lesser of 2%, or the CPI index.
What are the tax implications for homeowners who sell their primary residence and move from a different county in California? So someone goes from San Diego to Riverside County, Orange County to San Bernardino County, et cetera.
Yeah, so under Prop 19, you're no longer limited by the same county or reciprocity requirement. Now they open it up, so not only can you do it 3 times, you're not governed by the equal or lesser value limitation. You can also move to any county in California, all 58 counties, anyone, doesn't matter.
That's huge because I do remember folks selling in Orange County. If I remember correctly, they couldn't go to Riverside County, for example. They could go to San Diego, could go to LA, but they couldn't go to Riverside. And I don't believe San Bernardino and enjoy, I like that word you used, enjoy the lower property tax, but now they can.
Right. Yeah. And same thing with Southern California and Northern California. There wasn't a lot of reciprocity there. So it really limited people, but now you can. So you have the opportunity to take advantage of that exclusion in any county in California. You can't, move from out of state into California and transfer it because most states don't have Prop 13 anyways. So you wouldn't, it wouldn't be apples to apples, but you also can't take your California Prop 13 basis with you out of state either. Again, it's governed by different rules. So it doesn't translate that way. But and within California, you're free to go.
What strategies can homeowners use, if any, to minimize tax increases under Prop 19?
Like we talked about, Prop 19, well, for all the benefits it provided under the base year value transfer exclusion, it limited the ability for parents to transfer properties to their kids or vice versa, transferring property intergenerationally pretty significantly. So there's other property tax rules that you might be able to take advantage of. It requires some explanation more so than we have time for today, but just generally speaking, the rules that you're aware of is joint tenancy rules. You can use joint tenancies to your advantage to take advantage of avoiding a reassessment by getting a property from one person to another. And also legal entities. You can use legal entities to transfer interests amongst individuals and get property ultimately transferred between 2 completely different individuals or a group of different individuals with either a small reassessment or no reassessment at all if you have enough individuals involved. So there's different options out there totally outside the scope of Prop 19 that might be available to you that might be worth looking into and taking advantage of. And I should note, they're great for property tax purposes with some caveats, but they might not be great for income tax purposes, which is, admittedly outside my area. So when you're considering some of these options, you want to make sure you kind of have a team assembled who can wade through the pros and the cons of each on each side, both property tax and income tax, and make sure you're making the right decision for you and your family comprehensively.
Yeah. So listeners know joint tenancy is just a way of taking title of a property. Whenever you buy a property, you have choices on how you want to hold title. And joint tenancy is just one of, I think, probably 4 ways of holding title for a property. And that could be another show. Have there been any significant changes in real estate tax laws or regulations in California in the last year?
Yeah, so we've been talking a lot about property tax, but there's also a tax known as the documentary transfer tax that's imposed on sales of real property that applies. And with respect to Los Angeles, the city of Los Angeles in particular, there was a significant change that's impacted a lot of folks. It was posed as the mansion tax, and it's under Measure ULA. It was passed back in 2022, went into effect as of April 1st, 2023, and it increased the documentary transfer tax that applies to sales of property that meet a certain threshold. There's 2 tiers to the threshold. The first is properties that are sold greater than $5 million or more. An additional 4% of the consideration transferred is tacked on to the base 0.45% documentary transfer tax.
That sounds like one of the few times that I'd have a seller counter less than 500.
A lot of people were doing that leading up to the deadline and shortly after the deadline, as they were trying to negotiate values that didn't meet that threshold because it was a significant driver in these sales and it really impacted the way people thought about how they were going to do this. And so that's the first threshold, is $5 million. Any transfer of value, a consideration, $10 million or more, tacked on a 5.5% documentary transfer tax, again, on top of the already base 0.45%. So it was a documentary transfer tax of 5.95% due at the time of sale, the recording of the deed, transferring the property. And so that was a significant change that impacted real estate taxes in California, and particularly in LA City. It's jurisdictionally dependent, so not every city or county has it. San Francisco has their own measure, but it's significantly high like LA's. But LA, is a big city, and it's impacted a lot of sales. And it's a adjusted threshold. They adjust it annually to account for inflation. And so as of any transfer that's July 1, 2024 or after, the tiered measurements are 5,150,000. If you transfer a property that's in excess of that, you get the 4% tack on. And then the upper tier is 10,300,000. So that's the new threshold. Now, if you're at 5 or 10, you're below the threshold technically. So they adjust to account for inflation, which is helpful, but it's still, it's not limited to residential or commercial or industrial property. It's all property.
Oh,
it's not just limited to mansions. So that's where a lot of people got surprised, because it was deemed the mansion tax, but it's not limited to mansions. It's limited. It's open to any type of property that transfer easily exceed those values.
yeah. Two questions. So one is that the mansion tax, that is kind of county specific. Is that what you're saying? Or is that?
Right. Yeah.
Okay.
So if you're outside LA City, you're not going to be subject to those higher taxes. There's still a base rate. Usually it's, $1.10 per thousand typically. LA City has that specific measure that was passed that impacts property.
Does it apply in Orange County?
I don't believe so, unless they've changed it, but it's Orange County should be $1.10 per thousand last time I checked.
Of course, if you think about it, it's kind of a good problem to have as far as owning something that's worth that much, but still someone else is stealing or taking your money. So in any event, okay.
Or upset. And again, it changes the conversation with respect to sales of these properties, who's going to pay it. And it just adds a whole another layer onto the negotiation of these sales.
And then didn't Prop 13, this is actually, I told Michael the question, so we would review them in advance, and he knew what was going to be asked. This is kind of a new question, but Prop 13 no longer applies to industrial and commercial buildings. Is that true? Real estate?
No, Prop 13 is again, that's our overarching system that applies to all property in California.
I guess what I'm getting at is I had heard whispers, read places that they were trying to repeal Prop 13 for commercial and industrial buildings. I don't know. Any news that you've heard about that?
Not that I've heard, no, or nothing that's come too close to that.
Good.
But it should apply to all properties in California. And Prop 19 limited your ability to transfer traditionally commercial or industrial properties, because those aren't occupied as your principal residence. You used to be able to transfer those up to $1 million of trended base year value, and Prop 19 did away with that. So that might be something that they're referring to, but nothing else that I'm aware of.
What should homeowners and real estate investors be aware of when it comes to recent changes in property tax assessment?
Yeah, the main thing is, again, you don't have the $1 million exclusion, so you can't transfer investment property to your kids without a reassessment. And you have to be proactive when you're talking about transferring property intergenerationally. So because of that limitation on the parent-to-child exclusion, you could still get around the rules of reassessable events, but you have to be proactive. You can't wait until a parent dies and then, want to start paying attention and find out, how can I avoid this reassessment? When the parent dies, for property tax purposes, that's the transfer date. The property transfers from the parent to whoever they called for it to transfer to in their trust or their will or through intestate succession. You have to be paying attention. You want to be proactive and setting things up ahead of time, again, using either those joint tenancy rules or legal entity rules to take advantage of these property tax exclusions that exist outside of Prop 19. The other thing is LA has assembled a task force, as far as I've been told, that is looking out for individuals who are trying to avoid ULA to sell properties in ways that don't exceed that threshold, piecemeal over a series of days. They've assembled a task force to look out for incidences like that, to catch them, impose the tax, when they see that there's been a clear circumvention of the rule that should otherwise apply. And so, it's not as easy to be clever these days to try to avoid that. They're paying attention. They know, people, I think they expected that people were going to try to be.
Would an installment sale? That's a very rarely used sale, but do you know what an installment sale is? And frankly, it's so rarely used that I'm barely familiar with it. But from my recollection of my broker's exam 30 years ago or so, it's when I believe that they just make a certain payment each year for, let's say, 5 years. So if someone's buying something for, let's say, $5 million, and they just like $1,025,000 in 2024, $1,025,000 in 2025. Does that ring a bell or anything on that?
I'm not familiar. It's an interesting question. I would imagine that the assessor would argue that they would view it from A to Z and collapse it together. There's a doctrine called the step transaction doctrine. They look at individual steps that were taken that might not otherwise be reassessable or might not otherwise be subject to the ULA documentary transfer tax, but when viewed as a whole and together should be, and they can argue that step transaction doctrine, collapse all the steps together, and either reassess the property if it's a reassessable event or impose the documentary transfer tax if it should have been subject to that tax. And really for documentary transfer tax, it's an excise tax for the privilege of transferring real estate. You would probably look at that installment sale as one purchase, one sale of real estate. And if you're at $5,150,000, if it's July 1, 2024, and it's just paid over time, I would imagine they try to impose the tax. Maybe you try to argue otherwise, but it might be an uphill battle. Like Prop 19, people they need to be paying attention to these propositions that are introduced, because a lot of times they're advertised or phrased in a particular way, misleads people.
A lot of times, or I would almost caution to say every time. I mean, the Blank Reduction Tax Act, and what does it do? It increases the tax. It's just amazing.
You wouldn't believe the amount of calls we get related to Prop 19 that people were like, I voted yes on it, but I had no idea it was going to impact me in this way. I just didn't know.
What's the most common mistakes owners make when dealing with property taxes in California? Is there something that happens a lot?
Yeah, something that we see a lot is, I touched on it earlier, and folks looking to refinance, a lender advises them to transfer the property temporarily. Hey, we'll just kick it out of your trust and give it to your daughter. She's got better credit, and we'll kick it back into the trust just for the financing transaction. Well, that grant deed that's recorded is going to cause a reassessable event. Might qualify for Prop 19, but most folks don't recognize that. They think, oh, I'm just doing this to get this loan. But you got to be paying attention to what you're actually recording and signing, because it could cause a reassessable event that you might be able to rescind if you do it and catch it in time and get prospective relief, but you might not always be able to get retroactive relief. That's something a lot of people don't pay attention to. And the other thing is people who are taking advantage of age 55 and over base year value transfer exclusion. To qualify, the original residence that you're transferring the base year value from and the replacement property that you're transferring the base year value to both have to be eligible for the homeowners exemption that we talked about earlier. And to be eligible, you can't own the property in an LLC. That doesn't qualify for the homeowners exemption. You have to own it as an individual or in your trust. So if you buy a replacement property in an LLC, a lot of people do it because, they buy a home that needs a lot of work and they don't want the liability while it's being worked on. So they buy it in an LLC while it's being worked on and then transfer it to themselves individually once the construction is complete. Well, because you bought it in that LLC, you have to both purchase it and purchase it as your principal residence. Well, you can't qualify for that principal residence exception, the homeowners exemption. So you wouldn't qualify for the age 55 and over base year value transfer. And a lot of people run into that issue, and LA County in particular has been really big sticklers on people who try to take advantage of that exclusion using LLCs. You won't qualify. So you need to really make sure you're buying it as an individual and keep the ownership the same from the original residence to the new residence. Find some other way to deal with the LLC.
In a nutshell, everybody moved to Orange County.
Yeah.
I'm just kidding.
Orange County.
I'm just kidding.
I'm all for that.
How can a homeowner challenge their property tax assessment if they believe it's too high?
Yeah, great question. So earlier I went through the appeals deadlines, the timelines by which you have to file an assessment appeal application to timely challenge a reassessment. By filing that assessment appeal application, you're raising a challenge to the value of that property in front of the assessment appeals board. Every county has their own assessment appeals board in California. You're basically challenging the assessor's value and arguing, hey, I think they assigned the wrong value, or my value of my property is decreased in any given year, and so it should be adjusted accordingly. And ultimately, once you file that appeal, you've asserted your right. You'd always want your appeal serves as your claim for refund. So you'd always want to check the box that you're designating that appeal as a claim for refund, because if you're successful, you want to get your money back. But ultimately, that appeal is going to get set for hearing, and you'd appear in front of an assessment appeals board. It's a 3-board panel for the most part in most counties, and you have to argue your case as to why you think the value is lower, or why you think the assessor got it wrong. And you can either hire an appraiser to come present with you, or you can do it on your own. But you're going to want to either present comparable properties, comparable sales, recent in time to the valuation date in question for your property. Or like I mentioned earlier, if it's an income producing property, you can do an income approach, but you got to present your case to the assessment appeals board. We treat it like a trial. That's what we do day in and day out. We argue in front of assessment appeals boards, challenging values assigned to properties throughout California. And if you're successful, the assessor has the opportunity to appeal it. And your appeal after the assessment appeals board level is to Superior Court, and a judge would determine whether or not the assessment appeals board determined the right value or not. If you want to go beyond that, you go to the Court of Appeal or the California Supreme Court. You can take cases all the way up to the U.S. Supreme Court if you had a viable case. That's the avenue that you have to challenge assessed values to properties. And there's different standards of review once you extend beyond the assessment appeals board, depending on the issue that's decided. That's what you're dealing with in California.
Sounds like a lot of fun.
We think so.
So can you discuss how property tax assessments work after the sale of a transfer of property?
Yeah. So that generally the recording of a grant deed will get to the county recorder and then pass along ultimately to the assessor's office, who will review it for a change in ownership event. Sometimes if the deed raises enough issues, it might cause the assessor to send out a letter requesting additional information to see if it truly was a reassessable event or if it qualified for exclusion. But just traditionally, they'll get the grant deed, standard transfer from person A to person B. They'll reassess the property. They'll do an analysis of what they think the fair market value of that property was as of that transfer date and issue a notice of reassessment, either a supplemental assessment or if the statute's gone, just an escape assessment or a series of escape assessments. But they'll issue that reassessment. And again, that starts your timeline to challenge that value that they assign. But like we talked about earlier, they have a whole process as to how they determine the fair market value to be, what they determine that fair market value to be. It's up to you to read into that, see if they did it right, if they're following the codes and the rules for appraisals, and challenge it if warranted.
I love this next question we have because this is a common one in my field. So what impact does adding improvements or new construction have on property taxes? For example, certain improvements, if I remember correctly, they don't necessarily trigger, like a new roof or new windows.
Yeah. So a new roof is specifically excluded under Revenue and Taxation Code section governing new construction. Repairs and maintenance, general repairs and maintenance, are also generally excluded. It's an addition to property, an alteration to property, or rehabilitation, renovation that renders the property's substantial equivalent of new is what constitutes new construction, accessible new construction. And so when you have accessible new construction to a property, that's going to set a new base year for the property. The only part that gets reassessed is the part that is new construction. But if you have a substantial renovation of the home that renders the home the substantial equivalent of new, that home is going to get reassessed as the fair market value of what that property is as of that completion new construction date. And that's going to be your new base year that gets reassessed.
ADUs are really popular now. I'm guessing that that's a huge trigger, let's call it, or for reassessment.
Right. Yeah. And the assessor's office usually gets notice of that via the permit process. They'll get forwarded on permits that are pulled to do construction on property and review it and analyze whether it should constitute new construction or not. Then they determine what that new construction is, determine what the fair market value of that new construction is. Oftentimes on the cost approach, looking at what the construction costs were to build that addition, add that value on to the assessed value for the total property.
ADU in layman's terms is a guest house. You build a guest house on your house. In
Right.
case people aren't aware. So I would tell you what ADU stood for, but I have a problem pronouncing accessory dwelling unit is what it is. So I didn't want to advertise my lack of intelligence there. So was that good?
I thought so.
All right, Michael, I have a question now from our audience. Posed this question. It happened to be my wife. If a stepdad and mom own a house and transfer it to the mom's child, will it 100% be parent to child transfer, or does the stepdad need to transfer it to his wife for it to be 100% parent to child transfer?
That's a great question. The stepdad can transfer the property to the child. A child is specifically defined under Revenue and Taxation Code. It's now Revenue and Taxation Code section 63.2. That's the Prop 19 version of the parent-to-child exclusion. It used to be 63.1. A child is specifically defined, and a stepchild constitutes a child under the parent-to-child exclusion.
Awesome.
So it's any natural-born child of the parents, a stepchild, a son-in-law or daughter-in-law also qualifies as a child under the parent-to-child exclusion, and that's only up to the point of divorce. So if they're divorced, the son-in-law or daughter-in-law is not a child anymore. Or if the biological child passes, that son-in-law or daughter-in-law still qualifies as a child under the parent-to-child exclusion up until the point of remarriage. So if that son-in-law or daughter-in-law gets remarried after the biological child passes, they'll no longer constitute a child under the parent-to-child exclusion. And any adopted child also qualifies as a child. so long as they were adopted under the age of 18. I think that's probably just to make sure people aren't adopting adults just to qualify for the rule, but not otherwise intending to adopt them as a parent. That's the definition in a general sense under the code. One other important thing to note, because we talked about the grandparent to grandchild exclusion, you only qualify for the grandparent to grandchild exclusion if the intermediate parent, so the direct child of the grandpa or grandma, is deceased. So if that one of those two parents is still living, the grandchild won't qualify for the grandparent to grandchild exclusion. The grandparent can't transfer a property to a grandchild if the intermediate parent is still alive. They have to both be deceased.
Interesting. Okay, so 615. Why does a refinance trigger an automatic reassessment, and why is the property tax assessor? I think we might have covered that. Did we cover? Is that? Oh, that might be a new question. I'm not sure.
It's kind of. I raised it as something that people often run into and unknowingly trigger a reassessment.
Should I ask it again, or did we cover it?
I kind of think we covered it in that, if you're just refinancing a property, and I'll just tell you generally, and you can tell me, if you're just refinancing a property and there's no actual transfer of title from one person to another, there's no reassessable event, generally speaking. There shouldn't be. If it's, a transfer from mom and dad's revocable trust that they're both the trustors of to mom and dad as individuals, that's just a change in the manner of holding title. It's not really a change in present interest, including the beneficial use of it. And so that's not a reassessable event. If you're doing a refinance that doesn't cause a transfer of title, it shouldn't be reassessed. But it's when you do a refinance that does require a change in title, either a percentage of or a complete change in title, that's going to cause a reassessment. And it's, again, recording of that grantee that puts the assessor on notice of that and causes them to reassess it at fair market value at the time of that transfer, which might be more than 2%. If you just bought a property last year and you're already refinancing it the next year, it might not have gone up that much, if at all. And so the reassessable event, doesn't really impact you in any way because you're already paying on that fair market value as of last year, assuming no exclusions. But it's when you have those significant gaps in time between change in ownership events that you could get hit with a serious tax hike and a reassessable event.
That makes a lot of sense.
And that wraps up part one of our conversation with Michael Kelly. We've covered some critical ground today, especially Prop 19 and the major changes it brought to property transfers in California, from understanding the base year value transfers to the limitations of parent to child exclusions. We've just scratched the surface of this complex topic. But don't worry, we're not done yet. In part two, we'll dive in even deeper into the trust transfers, strategies to avoid reassessments, and ways to protect your real estate assets. Make sure to tune into part two. You won't want to miss it.